We had examples of performing a pre-existing legal duty and therefore saying there was no consideration. One was where the contractor wanted additional money even though they agreed to build a certain thing for an exact amount of money and nothing more. And we also had the one about the sheriff having the duty to arrest any fugitive in his or her jurisdiction, such as the deputy sheriff that arrested Eric Rudolph. This is different from the example where the woman in the Jewish synagogue, because the reason why she wasn't allowed to get paid was because in some states it had to do with communication of the offer, not having to do with a pre-existing legal duty. A reward published in a classified section of a newspaper is an example of an offer. Normally, a classified ad is not an offer, but a reward is an example of that because it's a type of unilateral contract. Various types of damages that we studied in Chapter 10 included consequential, compensatory, nominal, liquidated, and punitive. The damages that are awarded to the non-breaching party for direct damages are what we call compensatory, and indirect or special damages are called consequential. That was Hadley versus Baxendale, if you'll remember. If a person is adjudicated incompetent by a court of law, then all of their contracts entered into after that time until they get their sanity or their competency restored are void, absolutely void. Landlords are required to mitigate their damages in the event of the breaches of a lease by their tenants. They are required to mitigate, which generally means try to find another tenant to take over the place. They don't have to find one for the same amount. They can find one for less and then charge the original tenant the difference. Unconscionable contracts, we said, are those that are fundamentally or grossly unfair or oppressive to one of the parties to the contract. Voluntary consent, as they restated it in the book, but I'll point out in the question that that was also known as genuineness of assent, A-S-S-E-N-T, is used where we decide that there's not a meeting of the minds. We had a number of cases involving mistake of fact, the one that I sent you the lecture on about mistakes, and we also studied undue influence and duress and fraud as different examples of where there was no meeting of the minds. In order to prove undue influence, we said that we have to also prove the existence of a confidential relationship. When you have a situation where the two parties to a contract have problems estimating what the damages will be if one of them breaches. Typically, this would be like a construction contract, like we said on Highway 321, the state has a similar clause, that if the company building that road falls behind, it's difficult to assess what kind of damage there is to the state of North Carolina because the road didn't get completed on time. It's more or less an inconvenience to you and me. And so they put a provision in there stating that the contractor will pay so many dollars per day if they're late, and for every day they're late. And that's called a form of liquidated damages. It should not be referred to as a penalty, because if it's a penalty, then that may not be upheld by the court. Courts consider that to be excessive if it's a penalty. We talked about that consideration includes not only agreeing to do something which you didn't previously have a duty to do, but agreeing to refrain from doing something that you have a legal right to do. And we use the example, if you wanted to paint your house a funky color and your neighbor didn't want you to, and they agreed to buy you some paint if you would paint it a color that you could both agree on. That is what we call a forbearance, or a situation where you're agreeing to refrain from doing something that you had a legal right to do. Speaking of foreseeability that we talked about in some different cases, we had foreseeability in negligence cases because it had to do with proximate causation. Was it foreseeable if Ackerman burned down the forest that it was going to cause the chemical plant and fish to die and all those problems. We also talked about it in Hadley versus Baxendale and said that if Baxendale didn't know that Hadley was going to lose money because they didn't have an extra crankshaft on time, then if it wasn't foreseeable, then Baxendale might not have been liable for that. Courts look at contracts with covenants not to compete with a very strict eye, and courts do not like these because they tend to restrain trade. In other words, if you bought a business and you got the previous owner to agree not to open a similar business within a certain period of time, then in a certain geographical area, it must be reasonable in time and geographical scope, and it must not create a greater restriction than is necessary to protect a legitimate business interest. That's pretty good timing. I'm slightly more than halfway through. Yeah, so you should get the other half on the other side.
Yeah.
Okay? All right. So, to repeat, a covenant not to compete is something that courts will look at very strictly because they don't normally like these, especially in employment contracts. And so they will uphold them as long as they are reasonable in time and geographical scope, and they protect a legitimate business interest. When one of the parties to a personal service contract dies or becomes incompetent, such as the example in the book, Fred could not appear in the ballet, then we have what we call impossibility of performance, and the parties are excused from the performance of the contract. There is no contract we know when there's a mutual mistake of material fact. The rule is simple. It's the cases that were hard to apply it to. There are torts that sometimes involve contracts, specifically torts involving fraud and misrepresentation, frequently involve contracts, and often are criminal as well as being a tort. So we have a one-word fraud that represents both a tort and a contract and a criminal case, all in one. Now, admittedly, you have to try the civil case separately from the criminal case, but when you've got fraud, it can involve all three. Contracts can be discharged by a number of means. This was in Chapter 10. Some of those that we listed were bankruptcy, impossibility, expiration of the statute of limitations, and frustration of purpose. Remember, that was the English coronation case, which weren't mentioned in the book, by the way. Suppose you receive a credit card offer and a card in the mail which you never requested. Now, on the sheet it says that a small service fee of $50 will be charged annually whether or not you activate the card. If you never use the card or activate the card, you are not liable for that because